Once again, good morning. Welcome from BDB Pitmans. My name is Tom Henderson. I'm one of the partners here at BDB Pitmans, and I'll be chairing today's webinar. For those of you not already familiar with us, BDB Pitmans is a full-service law firm with offices in London, Cambridge, Reading, and Southampton. Today's webinar focuses on the environmental assessment of major projects following Brexit, helpfully a topical subject following yesterday's Queen's speech, which we'll be touching on as we go through. And I'm delighted to welcome my colleagues Oksana Price and Oliver Spencer, who will be speaking on this subject. This is the second in our series of webinars guiding you through the legal landscape following Brexit. The series began towards the end of April with an introductory grounding on Brexit legislation, in particular the concept of retained EU law and how it's expected to operate. Hopefully many of you were able to attend that one, but if not, fear not, you can still access the video recording and watch that at your leisure, and we'll also be prefacing today's session with a recap of the key relevant concepts that you need to be aware of. Melissa, if you can move on to the next slide. So a little bit more detail about today's session. As I say, following a brief recap from me on retained EU law, I'll hand over to Oksana, who will be talking first about the Environment Bill, which helps set the scene for some of the specific topics that follow. She'll also look at environmental impact assessment and strategic environmental assessment before handing over to Oliver, who will be looking at habitats regulations assessment, air quality, and the Water Framework Directive. Just before we get stuck in some brief virtual housekeeping points. We've got up to an hour for the seminar, and we've allowed roughly 15 minutes or so for questions and answers. So please can I encourage you to submit any questions as we go along. And to do that, use the Q&A button on the bottom of your Zoom ribbon. We'll be able to see those questions as they come in, but just note you won't be able to see questions from other people that submit them. The chat function's also enabled, but can you only use this if you're encountering technical issues, and we'll endeavour to deal with those. But other than that, you'll note that your cameras and microphones are not enabled. Next slide, please, Melissa. So to start with a quick recap on the concept of retained EU law. Section 1 of the European Union Withdrawal Act of 2018, or EUA as it has been abbreviated, repealed the European Communities Act of 1972, thus removing the basis of much of the EU law that applied in the UK. Accordingly, the remainder of EUA dealt with the consequences of this, and it does this by creating a form of domestic legislation called, as I say, retained EU law. And this is EU law which had effect in the UK immediately before exit day and now continues to have effect in domestic law on and after exit day. It's, as you might expect, a very complex topic with numerous exceptions, which I can't really do justice to as a brief summary. But for the purposes of today, there are broadly 4 components to be aware of in terms of retained EU law. Firstly, EU-derived domestic legislation, so much of which is secondary legislation, indeed environmental legislation, which we'll be talking about, but also some primary legislation. The second component of retained EU law is certain EU legislation which was directly effective in the UK, for instance, EU regulations. Thirdly, there's a provision in retained EU law for any remaining rights, powers, liabilities, and obligations which derive from EU law, and that's really something of a sweeper provision. And lastly, the interpretation of retained EU law, and this is to be interpreted according to retained case law and general principles which derive from Europe. So in other words, case law and principles which applied at the point of Brexit will continue to apply, although superior courts, the Supreme Court and Court of Appeal, are not bound by those decisions and so can depart from them. So that's the basis of retained EU law, although of course it's subject then to the law as it develops in this country, and we'll be talking about that a bit later following the Queen's speech. Next slide, please, Melissa. We also just briefly wanted to mention something interesting in the trade and cooperation agreement, which you may recall was agreed on the 24th of December of 2020. Now that agreement contains a non-regression clause to prevent the UK and EU offering environmental protections. However, there's some interesting devil in the detail, which we've just mentioned here. You'll note that the non-regression is caveated, so environmental levels of protection won't be weakened or reduced, as I said there, in a manner affecting trade or investment between the parties. So conversely, that would suggest that where you can demonstrate that the weakening or the reduction doesn't affect trade and investment, then it's something that could be permitted. Having said that, there is a commitment to strive to increase respective environmental levels of protection, but again, there's some nuance in that, and there's no requirement for the parties to align dynamically as their respective regimes develop. So, I mean, we mention that really as it's certainly one to watch in terms of how the regimes develop from this point onwards, but there's no immediate short-term implications of this issue for major projects and their applications. So with that, Melissa, next slide, I'll pass the baton on to Oksana.
Morning all. Thank you for coming this morning to our webinar. As Tom said, I'll be covering the very important piece of legislation. We can't talk about post-Brexit environmental scene for major infrastructure and not look at the Environment Bill. Under the Withdrawal Act, the Secretary of State was required to actually publish this draft bill, which they actually discharged that requirement. It basically is intended to replace and add, I suppose, to some of the EU environmental regulation structure and to set long-term legally binding environmental targets to deliver on the very ambitious green agenda of the government. Just to give you a flavour of how the white paper in relation to the bill referred to it, it's designed to deliver the most ambitious environmental programme of any country on earth. One can certainly not fault the government on the level of ambition and the expectation for the bill, but the devil will be in the detail, and whether the bill will deliver on this ambitious agenda remains to be seen. As you probably know, due to the pandemic, the bill has been significantly delayed, and it's yesterday's Queen's speech, it's been reintroduced, and as some critics have pointed out, for the third time in the Queen's speech, it's been introduced. We're hopeful that perhaps third time lucky, and the bill will progress with some speed in the next parliamentary session. Each part of the bill in itself would probably justify its own webinar and probably a whole series. So I'm only going to focus very high-level overview of some of the key provisions in relation to some major infrastructure. So the key provisions, it sort of splits into several parts, but one of the key aspects is the environmental governance. And one of those things is the environmental principles and targets and improvement plans. So the bill sets a framework for legally binding targets to deliver the environmental improvements. It gives the Secretary of State a new power to require at least one long-term target in each of the following 4 priority areas: air quality, water, biodiversity, and resource efficiency and waste reduction. In addition to that, the Secretary of State might also set a target for PM 2.5, which is fine particulate matter in ambient air before 31st of October 22. And Oliver will cover that in more detail later. There's also a requirement for the Secretary of State to prepare environmental improvement plan. And the government's 25-year plan is to be treated as the EIP, as it is called. The bill itself is actually silent on the what the content of those target provisions will be, and there are some quite weak provisions that it allows the targets to be removed or lowered relatively easily. on grounds such as social or economic cost. So I think the critics are quite skeptical and think that this will leave the door wide open for regressive weakening of environmental standards, depending on the politics of the day. It may be strengthened when it progresses through Parliament. Also, under Section 16 of the bill, the Secretary of State must prepare a policy statement on environmental principle. For instance, one of the important principles that that we've been relying on as part of the EU law is the precautionary principle, and the government actually launched the consultation on the draft environmental principle policy statement, and if you're interested, it's still available and lasts till 2nd of June. The bill provides other framework for resources, waste strategy, and water and wastewater services, which we won't go into any detail today. It also has very important provisions in relation to air quality, and Oliver will cover those in detail. They really do deserve their sort of quite a lot of attention, given their significance. Of some relevance to major infrastructure are also provision in relation to biodiversity. The bill is intended to provide a framework to measure to support nature's recovery, as it calls it, and contains provision for a 10% biodiversity net gain requirement on new development. Although importantly, this does not apply to developments that are under permitted development rights, and also not to NSIPs. There's also strengthened biodiversity duty on public authorities and a very interesting new statutory regime of conservation covenants. It's basically to allow a private voluntary agreement between a landowner and a conservation body to enter an agreement that will endure changes in land ownership and therefore have kind of long-lasting protection for biodiversity. Can we have the next slide, please? One of the most important aspects of the bill is the creation of an establishment of the Office of Environmental Protection. It is intended to be the world-leading independent environmental watchdog responsible for taking actions in relation to breaches of environmental law. There's some of the specific duties are set out on the slides, but basically they sort of roughly fall into two categories of sort of advisory duties, but also enforcement powers that it will have. Although there's been a lot of criticism in relation to the enforcement powers and that the government may have missed a trick here. So the process itself is that they can issue sort of an information notice that followed by a decision notice, and then they can carry out something which is called the environmental review, which is basically a mechanism through which potential issues of public authority of non-compliance with environmental law can be brought to a judicial forum. Initially, this was upper tribunal, but I think currently stands it will be the High Court. The OP can also bring judicial review, but the problem with the current enforcement functions is that there is very little remedy of any substance. So one of the things, for instance, the court will not be allowed to award damages, and the decision notice isn't itself binding on the body, on the public authority in question. So it seems that the OP has quite a loud bark, but perhaps no teeth as a watchdog. Perhaps this will change, you know, as the bill kind of progresses, but there's something to watch out for. Another issue is the issue of independence potentially, given it's supposed to be independent. Its budget actually is decided by the government, and there's a provision in the bill that gives the Secretary of State the ability to issue the guidance on its duties and how it exercises its enforcement functions. So that could be fairly problematic when it deals with its independence. Even the body hasn't actually been, the OP hasn't actually been set up. We already have a chair, Dame Glenys Stacey. She was appointed back in December 2020. And from January, we also have the Interim Environmental Government Secretariat that already has received some complaints and published a report of certain of the number, at least, complaints made in relation to exercise of functions of public authorities. And from July 2021, we're going to have an interim Office of Environmental Protection, which will be set up in a non-statutory form. It's basically designed to accelerate the creation of the Office of Environmental Protection properly. The bill overall, it seems to be a step in the right direction, but to what extent it can actually guarantee to deliver the green Brexit we're promised remains to be seen. If we can move to the next slide, we will now look at the implications of Brexit and some of the key environmental regimes, starting with the environmental impact assessment and the strategic environment assessment. I just sort of give a bit of background about kind of where we were pre-Brexit. So the 2011 EIA directive set out the requirements that member states must ensure that public and private projects that are likely to have significant effects on the environment are subject to environmental assessment before development consent is granted. It was subsequently amended and streamlined in 2014 EIA directive, and those directives require in EIA to identify, describe and assess the direct and indirect effects of the project on human beings, climate, landscape, etc. Both of those directives were implemented in UK in a series of regulations covering different projects that are subject to IA, such as Town Country Planning Act and NSIPs and harbours, highways, railways and pipelines, amongst others. Next slide, please. The SCA directive was also implemented by the SCA regulations, and it basically aims to ensure that the member states integrate environment assessment into their plans and programs at the earliest stage and apply to any plan or program prepared for agriculture, forestry, fish and energy and the like, and set basically the framework for future development consent for certain projects. The SCA regulations themselves set out what strategic environmental assessment must include and the public consultation and other procedure relating to such process. The EIA regs for NSIPs and the SCA regulations form part of what Tom discussed was being sort of EU retained law under Section 2 of the Withdrawal Act, but the EIA and the SCA directives do not. It doesn't mean that they're redundant and of no relevance for major infrastructure projects, but they may be relevant to the interpretations of those regulations where there is any ambiguity. Next slide, please. The existing regulations were amended by the Environmental Assessment and Miscellaneous Planning Amendments regulations to make them basically function in the context of the UK, which is no longer EU member state. Depending on your view of the regimes, you may or may not be pleased to know that there are no substantive changes to either the EIA or the SCA regimes, and the only changes are basically removing unnecessary references, for example, to the United Kingdom being a member state, or a reference to the obligation under the EU law, which are redundant or are no longer appropriate. Therefore, the SCA and the EIA regime will continue to function as they did before Brexit. The only change perhaps to note is that when you're citing, for those people who sort of drafting EIAs, for those you're citing legislative authority for conducting the EIA or SCA under the EIA or SCA directives, you'll need to be referring to the most recent, to the regulations rather than the directives. Some practical amendments have also been made to allow environmental statements and supporting documents to be made available on the website maintained by the Secretary of State or on their behalf, as opposed to being made available, physically available. I think this is something that happened during the pandemic, and the temporary provisions that have now been have expired, have been revoked, have been replaced with more permanent, which is a welcome change given the size of the most major DCO applications that you'll probably be aware of. What about guidance? Should we, a lot of EIA and SEA rely on European guidance in carrying out those assessments. So the good news is that it's probably still relevant, although the Withdrawal Act doesn't specifically say so in relation to the exercise of functions of public authorities or the guidance, but it does say that the courts may have regard to anything done by the EU entity, the European Commission, so far it is relevant to any matter before the court or tribunal, and therefore, as those public bodies would be bound by the courts above them, this remains relevant. Next slide, please. An interesting case that's probably of relevance here, and a fairly recent case, is the case of Pearce and Secretary of State for Business for BEIS. This is the notable judgment for its restatement of key principles of law relating to the proper approach to EIA, and in particular to cumulative and in combination impacts, and also the effect of the amendments to the EIA directive made in 2014 and transposed in secondary legislation in 2017. It is also the first decision of the High Court since the UK's post-Brexit transition period to consider EU legislation as retained EU law, and the issue of discretion in judicial review proceedings relating to breaches of EU retained law. I won't go through the facts of the case too much, but it basically concerned the assessment of cumulative onshore landscape and visual impacts in the village in Norfolk, the grid connection site for the Norfolk Vanguard project, and also a second closely related project, Norfolk Boreas, for which an application for consent was submitted subsequently. The claimant argued that cumulative impact from the onshore project substations for both Vanguard and Boreas projects needed to be addressed when determining the application, that the Secretary of State failed to do so was unlawful and breach of environmental impact assessment regulations. That was their ground one, and ground two, that it was the reasons that they given in deferring the assessment was irrational. They succeeded on both grounds, and the High Court basically declined to withhold relief under Section 31 of the Senior Courts Act 1981. So important principle is that the High Court is bound by EU retained case law to apply the more exacting EU law test where challenge succeeds on the EU point of law and breach of the EA regulations. Can we have next slide, please? So what's next? What are the potential future changes? The government has announced its plans to reform the EIA process. This was back in July 2020, although there are no details of what that will involve. The only thing we sort of grasp is from the speech by the Environmental Secretary, where she stated, and I shall quote, "We can set out which habits and species will always be off limit, so everyone knows where they stand, and we can add to that list where we want better protection for species that are characteristic of our country and critical to our ecosystems that the EU has sometimes overlooked. Things like water voles, red squirrels, adders. We want everyone to be able to access an accurate, centralized body of data on species population, so that taking nature into account is the first steady step to an application." Actually, yesterday in the Queen's speech, the government further confirms government intention to reform, and in addition to the promise of the consultation on the EIA, the government is also proposing a planning bill, which is supposed to and I quote, use post-Brexit freedoms to simplify and enhance the framework for environmental assessment for developments. We don't know any details on what it will include, but a bill is expected to be brought to Parliament after the summer recess. The notes of the Queen's speech also say about the government's project speed in accelerating and improving delivery by looking to reform environmental regulation and to secure better outcomes for the environment. What any of those plans involve remains to be seen, but it is an area that we must keep under review, and change may come. I think that's it from me, and I'll pass over to Oliver to talk about the next regime.
Thank you, Oksana, and good morning, everybody. I'd like to talk for the next approximately 15 or 20 minutes about 3 of the key regimes that we come across when dealing with major infrastructure projects, starting off with the habitats regulations regime. As set out on the slide there, the regime derives from the Habitats and Wild Birds directives, which were some of the earliest pieces of European environmental protection legislation. Currently, they are enacted in the UK as part of the regime under the Conservation of Habitats and Species Regulations 2017. Those regulations cover a number of matters that are relevant to practitioners in the infrastructure planning field, for example, the protected species licensing regime. But today we're going to focus on what's called the appropriate assessment provisions of those regulations. Now, in a nutshell, for those who may not be so familiar with that process, this is relevant where a plan or project may affect what is called a European site. Now, broadly, they are either what's called special protection areas, or SPAs, which are designated under the Birds Directive as hosting important bird species, and special areas of conservation, or SACs, sometimes called SACs, which are designated either for habitat or species. Now, in a nutshell, the appropriate assessment process provided for under those regulations boils down to a 5-stage process that's often simply a 2-stage process, as set out on the slide. So firstly, where there is a plan or project proposed which is likely to have significant effects on a European site, there is a requirement under the directive and through the regulations that that plan or project must be subject to an appropriate assessment, which is the stage 2 on the slide there. Now, the appropriate assessment is an assessment of the implications of that plan or project on the conservation objectives of the European site or sites that may be affected by it. And the question that's really posed by an appropriate assessment is whether the plan or project will adversely affect the integrity of that site. Now, if it won't, good, and you can exit the process at stage 2, and subject to other planning considerations, you're sort of free to get your consent. If, however, your plan or project will or may adversely affect the integrity of a site, the general principle is that consent shouldn't be granted for that project, given the important level of protection given to that site under the directive and through the regulations. However, there is what's called a derogation or an exception to that general principle that consent shouldn't be given to plans or projects that would adversely affect the integrity of European sites. And that derogation is made up of 3 stages, all of which must be satisfied in order for the derogation to be relied on. Just very briefly, that is that you must show that there are no feasible alternative solutions that would achieve the objectives of the plan or project, but would give rise to less harm to the site in question. You must also demonstrate that there are imperative reasons of overriding public interest, or IROPI, why the plan or project should proceed, notwithstanding its impact. And lastly, that you must secure all necessary compensatory measures to offset the harm that your plan or project may cause. If we could have the next slide, please. So that was the position under the 2017 regulations. Now, in terms of the impact of EU exit, shortly before the end of the transition period, the government made statutory instruments, the EU exit regulations referred to on the slide. And as has been said for the other regimes, the purpose of those regulations was to ensure that the habitats regulations would continue to function post-Brexit. And so largely, there are technical and minor modifications, but the substance of the regime continues. It's important just to sort of pick up on a couple of terminology points. In the directive and across the European Commission guidance, there is reference to a concept of the Natura 2000 network, which is in short, all of the European sites in all of the different member states. Now, clearly for the United Kingdom, that concept doesn't really hold after Brexit. So the regulations have now been amended to refer to something called the national site network, but the substance of the relevant provisions is largely the same. Moving on to the EUROPE derogation that I was just outlining, whilst the substance of that derogation will continue to apply, there have been some important procedural changes. Under the previous pre-Brexit regulations, it was possible to ask the European Commission to give an opinion as to whether or not there may be EUROPE for a project. It's fair to say that that route was little used, partly because the timescales involved were completely indeterminate. But there was another instance where the European Commission had to be consulted, and that was where a plan or project would affect a European site that hosted what was called a priority habitat or species. Now, in those instances, pre-Brexit, the opinion of the Commission had to be obtained as to whether EUROPE, other than a very narrow set of reasons relating to human health, public safety, or what in the regulations is termed beneficial consequences of primary importance to the environment, were to be relied on. So in effect, where a promoter wanted to deliver a project for socio-economic reasons, but their project affected a site hosting a priority habitat, they couldn't go through the EUROPE process without getting an opinion from the European Commission. Now, given that the Commission no longer has a role post-Brexit, these functions have been transferred to the Secretary of State for DEFRA as the appropriate authority under the regulations. There is also an important additional change, and that is where the opinion of the Secretary of State for DEFRA is sought. They now have to consult with the devolved administrations and have regard to their views on the plan or project, and also to have regard to the national interest in adopting an opinion. Lastly, on the slide there's a reference to Ramsar sites. Now, although these are not European sites, they are sites designated under the Ramsar Convention as important international wetlands. Historically, the UK, as a signatory to that convention, has undertaken to give the same level of protection to Ramsar sites as European sites. And post-Brexit, the government has published a policy statement to the effect that it will continue to do so. If we could have the next slide, please. On the slide here are just some useful publications from DEFRA since the end of the transition period last year. The first note is a policy statement on changes to the habitats regulation since Brexit, and that really just summarises what I've set out on the last couple of slides, but nonetheless it's quite worthwhile reading. And secondly, there have been two sets of guidance published this year. The first one is a replacement of the earlier 2012 DEFRA guidance on HRA, or Habitats Regulations Assessments, and that really just updates that guidance to reflect the fact that the UK is no longer a member state of the European Union. And secondly, there's been some recent guidance published on how other obligations under the Habitats Regulations should be exercised post-Brexit. I've just put as the final bullet point on this slide a question really about the ongoing status or relevance of some of the European Commission guidance on HRA. And really, that's because I think in many instances the European Commission's guidance and also its methodological guidance on conducting HRA is much more detailed in places than the equivalent UK guidance. So to give a couple of examples on compensatory measures, there's a lot more detail in the European Commission guidance than in the equivalent DEFRA guidance. So given Brexit, there's a question to what extent practitioners should have regard to the Commission guidance as sort of filling in some of the gaps that may not be covered by the UK guidance. If we could have the next slide, please. So turning now to the air quality regime. Now, just to sort of set the scene here, there are two regimes in terms of air quality protection that we ought to be concerned with. The first is a domestic regime under the Environment Act 1995. Now, to summarise that regime in a nutshell, there was a requirement for the government to publish a national air quality strategy. As a duty on local authorities to carry out air quality reviews from time to time. Now, depending on the outcome of those reviews, the local authorities have powers to designate what are called air quality management areas, or AQMAs, and adopt local plans to improve air quality where there may be exceedances of relevant air quality thresholds. And lastly, there's a reserve power for the Secretary of State to issue directions to local authorities to require them to take certain steps to improve air quality in their areas. And this has been used most recently to require local authorities to take steps towards adopting clean air zones, for example. Turning to the EU regime, which is perhaps most relevant for today's session, air quality protection comes really through the Air Quality Directive of 2008, as implemented in the UK by the 2010 regulations that are referred to on the slide. In a nutshell, the directive and the regulations set what are called limit values for particular types of emissions and air quality standards. There's an obligation on member states under the directive to attain the relevant targets, and a continuing obligation thereafter to ensure that those targets and limit values are not exceeded. We could have the next slide, please. Thank you. As with the habitats regulations and the EIA regime, a raft of EU exit regulations have been passed in order to give effect to the Air Quality Directive post-Brexit. And they're set out on the slide for you there. I'm just picking up one of particular interest, the third on the slide, substituted a lower PM 2.5 limit. And that reflects sort of an ongoing tension between, on the one hand, the World Health Organization, which says that there is no real safe limit for particulate matter. And if there is a limit, it should be, it says, a limit of 10 micrograms. The European Commission had a much higher standard of 25. And as you can see there, the limit is now down to 20. If we could have the next slide, please. However, notwithstanding that the substance of the Air Quality Directive has continued, I think this is really an area where we will see more legislation and more progress in terms of tackling issues of poor air quality that really are of particular interest to major infrastructure promoters, particularly in the transport sector. To look at the sort of legislative landscape, we've had the government's Clean Air Strategy from 2019. Now that included a target to reduce the number of people living in areas experiencing particulate matter pollution above the relevant WHO guidelines by 50%. That's now been built on by the Environment Bill, which formed part of the Queen's speech yesterday, which introduces a range of additional statutory duties and powers in relation to air quality, which are summarised on the slide for you there. And perhaps most importantly, there's a duty of the Secretary of State to set a target for PM 2.5 before October next year. And it remains to be seen whether the government are going to go for the WHO tighter target or stay more in line with the European Union equivalent. If we could have the next slide, please. It'll be readily apparent that air quality is a major issue in most infrastructure planning projects, particularly in the transport sector, as I say. And to sort of illustrate this, we've had a recent ruling of the Court of Justice of the European Union, which relates to a pre-Brexit reference concerning whether the UK had sufficiently implemented the Air Quality Directive and was meeting its requirements, and that the court found that the UK was systematically and persistently exceeding the annual limit value for nitrogen dioxide in a number of areas, and that it had also failed to adopt appropriate measures to ensure compliance with the limit values, i.e. things like clean air zones. I think what this shows is that this is a hot topic, and campaigners, particularly on air quality, will continue to hold project promoters to tighter standards in relation to air quality, even if it remains to be seen to what extent the European Commission can impose a remedy on the United Kingdom as a former member state for this breach, and how it would go about enforcing that remedy. If we could have the next slide, please. Another sort of topic, just to sort of reinforce the importance that's been sort of focused on air quality, is the tragic case of Ella KISSI-DEBRAH. As many of you may have seen in the media, Ella's death was the first time that air pollution had been recorded as a cause of death. The coroner concluded in December last year that air pollution made a material contribution to Ella's death from asthma. More recently, the coroner has published what's called a report to prevent future deaths, which is essentially a sort of lessons learned and what the government can or should do to stop the issue reoccurring. The coroner found that the existing PM 2.5 limits were too high and recommended that legally binding targets based on the tighter WHO guidelines that I've referred to previously would reduce the number of deaths from air pollution in the UK. And that's really been seized upon by air quality campaigners and who are pressuring the government to do more in this area. We could have the next slide, please. So to sort of summarize where I think we are sort of going in this area, I think we can all expect there to be a higher level of scrutiny of air quality issues when applications for major infrastructure projects are brought forward, and particularly, as I say, transport projects, whether they're new roads or airport expansion proposals. As Oksana mentioned earlier, I think there is a question about the extent to which the duty on the Secretary of State to set a target for PM 2.5 is sufficiently robust, given that the current version of the Environment Bill includes a clause 3.3, which permits the Secretary of State to revoke or lower the relevant target in certain circumstances. It'd be interesting to see whether that remains in the bill as enacted. Turning to the role of future regulation, whilst there will be the OEP and it will have certain powers and duties, I think there is a big question mark, and certainly campaigners such as Client Earth have raised concerns that the structure and remit of the OEP will not be sufficient to hold government to account, and it won't really have the tools to replace the role of the European Commission, for example, in bringing infraction proceedings against member states. I think more generally, we can also expect to see more legal challenges on air quality grounds. We can have the next slide, please. Now, just to canter through the Water Framework Directive assessment regime, this is a regime that many practitioners will engage with when projects are promoted. So just to set it out in a nutshell for those who may not be so familiar with it, the WFD, as it's known, was passed in 2000. It's enacted in this country through most recently the 2017 regulations. Now, in a nutshell, the WFD is the legislative framework for the protection of surface waters and groundwater bodies. And the idea is that every surface water and groundwater body protected will achieve what's called good ecological and good chemical status. And there are some exceptions in relation to what are called artificial water bodies. Moreover, there's a general duty under the regulations for the Secretary of State and the Welsh ministers in Wales, and also the key environmental regulators, so the Environment Agency in England and NRW in Wales, to exercise relevant functions so as to secure compliance with the requirements of the WFD. If we could have the next slide, please. Now, this will come up in major infrastructure projects through what's often called the WFD assessment. So, for example, in relation to DCO applications, a project promoter must include within their application an assessment of the implications of a plan or project on WFD water bodies that may be affected. Similarly, with the habitats and air quality and EIA regimes, after Brexit, statutory instruments were passed to ensure that the WFD regime would continue to operate effectively. So there have been no substantive changes in the light of the 2019 regulations referred to on the slide. Schedule 5 modifies the application of some of the provisions of the WFD so that it works effectively as retained EU law. So for example, some of the provisions of the WFD that relate to sharing information at the member state level and also between member states and the Commission have effectively been disapplied in relation to the UK as it's no longer a member state. As mentioned on the slide, in the case of DCO applications, for example, a WFD assessment remains a prescribed application document, so there'll be no immediate changes to the regime. There was some talk, however, just before the agreement was reached with the European last year as to whether the UK in the future would look to get rid of some of the environmental assessment regimes, and in some instances the WFD was sort of singled out as a candidate for change or if not whole-scale repeal. Sir James Bevan of the EA made a speech last year on the importance of good red tape as he saw it, and really sort of pushed back against the idea that the WFD regime should be sort of diluted or got rid of. Thank you. Could we have the next slide, please? So to sort of summarize all of that, and I appreciate it, it's a large amount of information to absorb across a range of different regimes. So hopefully we've done justice to the subject in such a short space of time. But to sort of summarize what we have spoken about today, I think the key point to bear in mind is that the effect of the UK's approach to withdrawal from the European Union and the importance it placed on legal certainty by retaining the EU law that applied before exit means that by and large these environmental assessment regimes will continue to apply in much the same way, if not the same way, as they did before Brexit. However, as Tom noted at the outset, there are provisions under the Withdrawal Act for the courts to take slightly different views on how EU law may develop in the future, and it's only bound to pre-Brexit EU case law up to the level of the Court of Appeal, who may start to diverge in the future. So watch this space. As has been mentioned, this is an area where there are forthcoming legislative changes. We've gone through the relevant sort of prospective changes under the Environment Bill. Also yesterday, the Planning Bill was announced, so we wait to see the detail on that, but there is talk that there will be changes to or some modifications to the environmental assessment regime. And one of the other sort of wider points to take away is whether the new Office for Environmental Protection will do the job played particularly by the European Commission in holding member states to the requirements of the directives, and particularly its lack of financial penalties as a mechanism may mean that it is something of a toothless regulator, but we remain sort of the view that until the final Environment Bill is passed, we can't really take a view on that. And lastly, and sort of more generally, as Tom indicated at the outset, the EU-UK Trade and Cooperation Agreement does have a non-regression provision in relation to environmental standards, but it's not absolute. And as has been indicated, there is potentially scope for divergence in the future. So having summarized the talk, I'll now hand over to Tom to close. Thank you.
Thanks, Oliver, and thanks, Oksana, as well. We've now got 10 minutes or so for questions and answers. So thanks for the questions that have been submitted so far, and do please submit through the Q&A if you've got any questions. If I could invite Oliver and Oksana to put their cameras back on. First question we've had in relating to your section, Oksana, was around the referencing of EIA regulations, for instance, when drafting an ES, and the question was whether the references now to those 2018 exit regulations but I think the answer is probably they amended the 2017 regulations, didn't they? So
yeah, that's correct. So the reference should be to the Infrastructure Planning Environmental Impact Assessment Regulations 2017, which basically revoked the 2009 regs. So it's 2017 regs we still need to refer to.
So it's as amended. Yeah. Thank you. Then question from me. Obviously, the DCO forum is where many of these issues that we've covered tend to commonly come up. And I had a couple of questions which I'll throw open to both of you. I mean, firstly, to what extent does the existing suite of DCO guidance and advice notes reflect current law or evolving law, or do they need to be amended? So that's the first question. Second question, you touched on this, Oliver, but whether these changes will make what is a complex process even more complex, both in terms of the preparation of applications and their examination. So a couple of questions to unpack there.
Shall I kick off?
Yep.
I think in relation to the first question, some of the planning inspectorate advice notes on the development consent order process are probably in need of some updating. Some of them have been updated more recently than others, but I think they ought to at least refer consistently to the post-Brexit regulations so that everyone's clear which regulations ought to be looked at in the first instance. I don't know, Oksana, whether you had anything on that point.
Yes, I agree. I think the guidance in some aspects is out of date, and also it just needs to be more clear and flexible kind of process of updating as the law changes, I suppose, and just more flexibility I think is needed. No, we don't wait for sort of a big review, and as things change we can adapt.
And then in terms of the preparation
point,
the preparation of applications and then their examination, does this make the process more complex, do you think?
I think for projects which are sort of at the application stage now, or perhaps are in examination in the case of DCO applications, because there hasn't really been much development in the relevant law since exit was sort of completed on the 31st of December, there isn't really that much additional complexity. I suppose the issue will come in the future if the Court of Appeal and the Supreme Court start to diverge from some of the key European Court decisions, and whether it's going to create more complexity and confusion for those advising on what are the relevant principles and tests that you should be applying if you're dealing with what is now retained EU law but was once you were looking at the directive, say. And I think there is scope, as we've set out, for there to be some sort of divergence. I think it will, in the medium term, become more complicated until the courts have started taking a consistent approach on whether there is going to be continued alignment or shadowing of future European case law, for instance, or whether there is going to be a sort of more marked divergence within the parameters of non-regression.
Okay, thank you. Oksana, a question here around the EIA process that you touched on and the prospective reform to it. In your experience, are there particular aspects that you think are potentially ripe for streamlining or improving if the government is looking at this?
Yes, I think generally the EIA process, the legal process, is very robust, and it's a mature process and within sort of well-established consenting regime, and I think it does work. Obviously, in practice, there are areas that nothing is perfect and can be improved. I think one of the key things for me is probably sort of jumping on innovation and kind of digitalization of the documents. Given the volume, throughout the years, I think the the EIA has got much heavier in kind of paper production, and from sort of 100 pages gone to tens of thousands depending on the scheme. So I think it would be good to see that moving towards different approach. I think the pandemic, you know, as bad as it was, but it was helpful in moving in that direction, and hopefully that will be taken forward in legislation as well, not just the guidance and practice. Also, I think scoping can be streamlined and improved, so hopefully the government will look at that just to see how can the process be quicker in that regard, and all the parties that are involved in that, whether, you know, something can be done to kind of narrow the scoping process so that what is produced is more relevant to the project in question. I think also perhaps there have been some rumor perhaps of trying to amalgamate perhaps some of the regimes, and maybe that is a way to go, but it depends obviously how that would be done. We'll see what happens, but those are key areas, I think.
Thank you. And yeah, related question that's come in around the volume of EIA, which I think everyone has seen it grow exponentially over the years, notwithstanding that large projects were promoted a long time ago and are now. And the question was whether there's a role for or flexibility for MHCLG to direct the planning inspectorate during the management of applications to reduce the volume of EIA. I suppose it really comes back to that reform setting the tone at the outset as to what's expected of a competent ES. Anyway, let's move on. We've had a question, Oliver, on the PM 2.5 point you mentioned, the 20 microgram target. Question around where that specifically bites or engages. Is that in the AQMA process?
My understanding is it's substituted the relevant limit value from 25 to 20, so it's part of the implementing regulations for the Air Quality Directive, or as they now are, the retained EU law of the air quality regulations.
Thanks. And question also for you, Oliver, on the HRA process you mentioned. Obviously, in recent years, EU case law has seen a tightening of certain aspects of the HRA regime, I think in particular around the status of mitigation at the screening stage. So the question is, given that the superior UK courts aren't bound by European decisions, do you foresee this being an area where the UK interpretation will soften?
It's an interesting
project going through the screening process.
Yeah, it's an interesting question. I mean, the case that's often referred to as the People over Wind decision, where this principle was clarified in the HRA context, and it caused a few ripples when it was decided 2 or 3 years ago, because the approach in domestic law to the same process in relation to EIA was markedly different, in that when you're screening and scoping a project for EIA, you are entitled to look at mitigation measures, which the European Court said was not permissible in the case of HRA. And whilst I think the judgment was pretty clear, and the reasons for ignoring mitigation in the case of projects affecting European sites are well made, equally, I think there is a concern that as a result of that judgment, a large number of projects will need to go through the appropriate assessment process, because the mitigation that will sort of inevitably be provided to avoid adverse effect on integrity can't be taken account of at the earlier stage. And some may view that as, an unattractive outcome, when, really when you look at the actual effects of a proposed project versus the, hypothetical effects without mitigation, you can see that actually, significant effects wouldn't arise. And there may be, in the absence of legislation, perhaps a desire on the part of other parties affected by the process to bring proceedings or raise these points in proceedings in order to get the law clarified so that it's more in line with EIA. And as you say, the provisions under the Withdrawal Act enable both the Supreme Court and the Court of Appeal to do so. Whilst there hasn't been a case yet, I mean, I think we can expect the point to be taken, or at least tested at some point.
Thanks very much. Well, looking at the time, we've just reached the midday, which is the end of our allotted time, so we'll draw things to a close there. Many thanks to Oliver and Oksana for their sessions today, and thank you to all of you for listening and asking some interesting questions. We'll be sending around a link of today's session video recording and also a copy of the slides, so you can share those with your colleagues. But other than that, we'll wish you an enjoyable remainder of the day, and do please look out for future webinars in our Brexit series.